if there is a dispute between myself and Hackman, and we are able to solve the dispute without going to court, we have entered into an ADR arrangement. But more specifically, the Act, which I said regulates ADR, in Section 135, defines ADR as a means, or it says ADR means the collective description of methods of resolving disputes otherwise than through the normal court system. So like I said, any dispute between 2 or 3 parties may be resolved, and we are being admonished not to go to court, but to make sure we settle our disputes amongst us. Okay. Why the need for ADR? I've said it already, because it is cost effective, because it is flexible, because it is confidential. You know that when you go to the court system, or when you go to the litigation, there are rigid, very rigid rules. Your case may be right, but because of a little slip in procedure, you are going to lose. But ADR makes things flexible, it is confidential, and it helps us to protect relationships. It also reduces the risks to our professional reputation because it is confidential. Nothing said in ADR goes out, and so we are able to maintain that. It minimizes legal costs, and it also preserves relationship, and it fosters resolution of the conflict. Okay. So what is the legal framework that regulates ADR in Ghana? The first legal framework is the 1992 Constitution. We all know that it is the supreme law of the land. And what it says is that, in Article 19, ensures the right to fair trial. And when we talk about right to fair trial, we are talking about access to justice. And how do we get access to justice when our courts are choked? In fact, if you take the rate at which cases are filed in court and the number of years that it takes for the settlement of those disputes, you will marvel. Recently, in 2023, a case which borders on boundary of land between 2 families took about 96 years to be resolved. The case started in 1927, and it was closed last year in 2023. So you can see the expense, you can see the waste, you can see the number of people who have even died, because 96 years, you can see the number of people. I mean, the waste of resources. If they have resorted to ADR, it would have taken them maybe a month, 2 months, because it is just about the boundary of their lands. And they wasted all these 96 years in court. Again, Article 125 mandates citizens to exercise popular participation in the administration of justice through the institutions of public and customary tribunals. The ADR mechanisms are one of the ways that we can use to resolve our disputes. Okay. The second law which regulates ADR in Ghana is the Courts Act, 1993 Act 459. And this act mandates people to use court annex ADR to solve disputes. So in court annex ADR, when even you go to court in litigation, the judge is mandated to look at the issues that you brought to court. If it's in the wisdom of the judge, he feels that it can be best be resolved through ADR, the judge is mandated to send you back to ADR. Of course, with your consent. If you say you don't agree, then that one, that's nobody's palaver. So the courts are now mandated to send people to ADR. Okay. The next major legal framework is the Alternative Dispute Resolution Act 2010, Act 798, which came into effect on the 31st of May 2010. Sorry, it came into effect in May 2010. And so that has been the principal legal regime that regulates ADR. And it provides a legal framework which enhances access to justice. It promotes reconciliation and amicable settlement of disputes. It improves efficiency in dispute resolution, and it ensures that enforcement of ADR outcomes are readily effected through the courts. So what are the uniqueness of this Act 798? One great uniqueness is that the Act combines arbitration, mediation, customary arbitration into a single act. And that is very fantastic because that is what is done outside of the jurisdiction. It also merges domestic and international arbitration into one statute, which follows the line of the New York Convention. And thus our Act 798, has attained an international character with this merger. Yeah. The Act, again, has specific provisions which are of international repute. And I would like to touch on a few. The Act in Section 3 talks about separability of arbitration agreement. What this means is that in every agreement, we may have the overall agreement, and within that agreement, we must have a special arbitration agreement within that or separately. And it is a principle that that arbitration agreement is always separate from the main act, in the sense that where the main act is held to be null and void, still the arbitration agreement will still work. And this promotes ADR. Again, the Act in Section 2 specifically says that an arbitration agreement must be in writing. This is in line with the New York Convention, which also provides in, I think, Article 8 of that convention that an arbitration agreement must be in writing. The Act talks about party autonomy. What party autonomy means is that the parties have the right to opt for arbitration. No, it is not by force. So the parties per themselves are able to say in their agreement that if in the course of this agreement, any issue arises, we will want to solve that issue by arbitration. That is party autonomy. Again, in the same party autonomy, the Act has provisions which says that the parties may choose their own arbitrators or mediators. They have the right to choose whoever they want to be their arbitrator or mediator, in the sense that if they have a boundary issue and they know you as a professional surveyor, they can quickly come to you with the expertise that you have for you to solve that dispute for them. And the decision that you are going to take will bind the parties. So party autonomy. The Act talks about an arbitrator as an amiable compositor. What this means is that as an amiable compositor, you as the arbitrator, you have the right to determine the result and give an award, not based on law, but you base your decision on equity and justice. So in arbitration, specifically, the arbitrator acts as an amiable compositor. And it says that the award, the decision which is made, that's what we call award. In every arbitration or in mediation, in customary mediation, the decision, as for example, we say a judgment of the court. In ADR, it is called an award. It's final. Once the parties sign, and it is final. And you can enforce it the same way as you enforce a judgment of the court. Okay. Another act which talks about or which promotes ADR is the Labor Act 2003, Act 651. And we all know that I said earlier on that wherever there are human beings, conflicts are bound to happen. And we know workers and their managers and all, there are always strikes and things. So this Labor Act also helps in promoting ADR. Okay. Now this is our babe because we are land surveyors. In 2020, we know that this act, the Lands Act 2020, Act 1036, was promulgated to regulate issues confronting us on land. And the act recognizes and promotes the use of ADR mechanisms in the resolution of land-related disputes. This falls in line with the ADR Act, which provides the legal framework for resolving disputes through arbitration, mediation, and customary arbitration. There are about 20 different provisions in the Act which supports arbitration or ADR. And I will not be able to go through, or they say I should be introducing you to the topic of ADR. So the slides are there. You have to go and read so that we make up. But I would like to touch on section 91(2). Yes, section 91(2), which is about title registration on general boundaries. And it says that whenever there is a dispute about general boundary of any land, the land registrar will have to call on surveyors, land surveyors, to solve that problem. And when it fails, then it will go through ADR processes. Let me quote the act properly. So the act says that 91(1), it says the registry map and any plan filed in the registry indicates only the approximate boundaries and the approximate location of a parcel shown on the map and the plan. Where an uncertainty or a dispute arises as to the position of a boundary within a registration district, the land registrar shall advise the claimants to refer the dispute to resolution under the ADR Act 2010, Act 798, for the purposes of determination and indication of the position of the boundaries. And it goes on to say that in 4, it says that a court shall not entertain an action concerning a dispute as to the boundaries of a parcel within a registration district unless the process of settlement provided in this section has been exhausted. So this section promotes ADR. It says that a court of competent jurisdiction should not touch on any land But the emphasis here is that in a registration district, in a registration district, this is not to oust the jurisdiction of the court, because the jurisdiction of the court has been given by the Constitution in Article 125. And so no statute can oust the jurisdiction of the court. But in a way, this act is promoting ADR in the sense that it said before you go to court, you must make sure you go through ADR as provided by this section. So like I said, there are about 20 of such provisions which talks about the Land Act and ADR. Go. Okay, so I think I've spoken about this, and I emphasize this with the quotation in the Bible, Matthew 18:15-17, that we must go through negotiation. If negotiation fails, we go through mediation. If mediation fails, we go through arbitration. We in Ghana are fortunate to have an added dimension of customary arbitration into our act. So we have 4 in 1 in the act. Go. Okay, so what is the process of ADR? Processes of ADR. When you are preparing for ADR, the key issues you have to do is that you identify the issues that has been brought to you. Once you are able to identify the issues that has been brought to you, you will then go on to choose the ADR mechanism that will best fit the problem that has been brought to you. And then you go through it by gathering evidence from the parties and then weighing the evidence that they have brought to you and then going on to give your decision. Once you have gone through an ADR mechanism, be it mediation, arbitration, or whatever, you must make sure the award you give will be enforceable. And to be enforceable, there are certain vital issues that you must follow. For example, I just mentioned that the arbitration agreement must be in writing. And so if your agreement is not in writing, it may be a ground for setting aside the award that you give. Again, there are certain topics or there are certain issues which are not arbitrable. Section 1 of the Act talks about them. It says that issues concerning the environment, issues concerning criminal, and then issues concerning the enforcement and interpretation of the Constitution are not arbitrable. So if you engage in an ADR by going into an issue which is not arbitrable, it may be a ground for setting aside the award that you get, and the award will not be enforced. Okay. So what are the roles that we as land surveyors can play in ADR? We can act as expert witnesses, or we can act as expert witness statement and in arbitration and mediation. Because of our expertise, we may be called upon to give expert advice, and that will go a long way to settle the dispute. I know we have been playing this role by working as court experts to assist the courts in determination of land issues in the court. But now we are being offered the opportunity to, by ourselves, be the judges and then dispense with disputes as they come along. We can also play the role of being an objective supporter. In order to resolve conflicts without resorting to legal action, parties offer objective and precise technical information regarding property lines, boundaries, and geographic data. Once we are able to do that, you see that we are able to solve whatever issues are brought, and it stops the parties from going to court. We can also act as technical consultants to arbitrators and mediators. I just highlighted about only four mechanisms. I said negotiation, mediation, arbitration, and customary arbitration. But there are other joint mechanisms. We have mini trial. We have rent a judge. We have med up, mediation, arbitration, and others. So all those mechanisms are there. And based on your expertise, you may be called upon to offer such technical advice to the parties, and that will serve as an end to the litigation. We then also goes in by helping once the agreement has been reached, we help in the settlement of the agreement, preparing the agreement. As surveyors, we assist in creating legal description or maps that are incorporated into settlement agreements once a dispute has been settled. The final agreements, that is its technical soundness and conformity to the property's physical parts, are guaranteed by the surveyor. As a result of our role, we are also able to prevent conflict by letting the conflict escalate into the courts, because we are able to assist in identifying possible points of contention and supplying documents that could stop disagreement and all that. For example, in a case which was settled in 2012, the court commended the efforts of the land surveyor, whose thorough border report assisted parties in reaching a negotiated settlement without going to trial. We also serve as legal assistants for surveyors, and this requires our experts in terms of witnesses in land disputes, and we act on the reports. The courts, or we as surveyors, when we are acting as mediators or arbitrators, our reports are acted upon, and this helps in resolution of the disputes. We know that we are neutrals, and as professionals, we must adhere to the ethics of the profession. So in conclusion, I can say that the time is now ripe for us to opt onto the arena of ADR. We have the expertise. We can do it. It is just that we don't know. But now we are being reawakened that there is this field for us to pursue. We should not restrict ourselves only to go into the field to capture data and prepare plans. This is another opportunity for us to expand our horizon. And so, as Professor Fiajo said, may our societies continue to drink deep from the wells of conflict resolution and management. ADR has become the preferred choice for the resolution of conflict and disagreement, and the reasons are not hard to find. It is faster, it is a private mechanism, it is less costly, it is less time-consuming, it is more conclusive, it is flexible and informal, and it protects relationship. On that note, I thank you for your attention.
Thank you so much, Senior Counsel. I know that as surveyors, we may have ventured into ADR a lot of times. Whilst in the field, a lot of issues confront us, and we are able to, even when langars come and you're able to speak to them and they speak, you have done some form of ADR. So I wish that, or if I had my own way, and if there is a way, it's possible, then surveyors must rather take the lead in resolving some of these land issues that come before it gets to court. So I know you have a lot of questions that you will be asking. Please jot them down. The lawyer will take some water, but before he takes your questions, we will take another presentation. And this time it is going to be by our own brother and senior Eric Okante. As you all know, but our profession is governed by a lot of laws, not too many. At least we know the Lands Commission Act 2008 at 767 is one of them. We also know the old Act 127, that is Survey Act 1962, is also in existence. And out of that act, there was LI 144 that came out, and which is also still operational, except that I think section 11 of the 127 has been repealed. So there is also the Lands Act 2020, that is 1036. So out of this act, when necessary, there is supposed to be an LI which will at least operationalize the act by itself. And so this afternoon, we are having Surveyor Eric Okante here to throw light on the work that has been done on the LI that is directed at the 1036. So I will want to ask him to.
Sorry, you're having some small technical issue. You'll be with you soon.
Hi. Good afternoon to everyone, and I welcome you all to this presentation. So this presentation will focus on the the Lands Commission Act 2020 at 1036. You will recall that this act was passed in 2020, and a section of the act mandated us to prepare or develop an LI to operationalize the Act 2020 Act 1036. So what I'm going to do this afternoon is to go through some of the provisions that we propose as Survey Mapping Division when Lands Commission put together a team to develop the LI for the Land Act 2020. Yeah. So we will look at the matters arising, which will be power to demarcate or survey, power of entry and survey, erection and protection of boundary marks and survey beacons, land valuation issues, registration of land title to land, and updates of the draft, where we have gotten with the draft so far. So as I have said already, the Act actually limited by Section 280, limited us to only two parts of the Act, which is power to demarcate and then power to erect, power to enter and survey. So we are limited within these boundaries and we cannot go beyond that. So the proposals we made in the development of the Act was within these boundaries. So the first one is power to demarcate or survey, which is Section 23 of the Act. If I can quickly read Section 23 of the Act, that's a small thing. Power to direct demarcation of survey. The Lands Commission may, subject to Clause 2 of Article 18 of the Constitution and any other relevant enactment, direct A, the boundaries of land to be demarcated, a land survey be carried out of any land, or the boundaries of a land be demarcated, and a survey carried out of that land. Now, so what proposals did we make in respect of this particular act? We said that a request in the direction of survey to be conducted, a request should be made for the conduction of demarcation and survey, and the request should contain certain information, name of client, purpose, locality, approximate acreage of land and district. This will come in the form that the request will be made. And then also we said that the survey shall be carried out in line with the technical instruction of the Survey and Mapping Division or as directed by the Director of Survey. So in respect of the technical instruction, there's an existing technical instruction now, which I think was done, if my memory serves me right, about 2014. Over the years, we know technology has changed, it's dynamic and it's changing, and therefore we may have to have a look at the Act again. We started having a look at the technical instructions, but it has not come into completion. Once references are being made to the technical instructions in the development of the LI, it is important. It has become very, very pertinent that we go back into the technical instructions and finish it up. So to inform you, we'll go back again to the technical instructions, even though the current one is existing until a new one has been done. But we'll go back into the technical instructions again, and then we'll have to update it. Now, Section 23, power to direct demarcation, still on the Section 23. We have issues where foreigners come into our space and they engage themselves in mapping process, and you don't actually know where they are coming from. Nobody is regulating them, no licensing, and it's a worry. So we decided to put in the provision that a foreigner cannot conduct survey works in Ghana unless he is permitted by the Director of Surveys. And when permitted, work in collaboration with a licensed surveyor or an official surveyor appointed by the Director of Surveys. So this proposal that we made into the LI is very important to forestall situations where foreigners will just enter into our space and find themselves conducting surveys without the knowledge of the appropriate regulators, which is the Survey and Mapping Division. And then also, demarcation and survey of draft planning schemes should be carried by the Director of Survey or a licensed surveyor appointed by the Director of Survey before it can be adopted by the Spatial Planning Committee. This we see as very, very important because you know what happens with the planners, especially those who are developing our planning schemes. Most at times, schemes are drawn without a properly surveyed base maps. So you have situations where implementing those schemes on the ground becomes a problem because you have situations with shifts. So we are saying that demarcation of and survey of such plans or for lands for these purposes has to be carried out by the appropriate authority, for us to be able to validate and be sure that the plan or the land that has been surveyed is okay, so that when planners are using it, we are sure that there wouldn't be any shifts. And then the second part of the power of entry and survey, which is section 24. Let me read a little part of it. 1, the Lands Commission may, in writing, authorize any official surveyor or licensed surveyor to enter upon any land to carry out the demarcation or survey work specified in the authorization. So we decided to put in this very provision that the Director of Survey in writing may authorize any official surveyor or licensed surveyor and his or her assigned to enter any land and carry out demarcation of survey. Now, in doing that, the appointing authority must give out this information to the official surveyor or the licensed surveyor, which are contacts of the authorizing power, address of the authorizing power, name of the appointed surveyor, name of the authorized workman of the appointed surveyor, rank of the appointed surveyor, and then the ID of the appointed surveyor. This will come in a form, or a letter form that will state all of this important information, authorizing the licensed surveyor or an official surveyor to conduct a survey. Then section 25, compensation for damages. We know that sometimes when surveyors are working, especially in areas where we have farm areas, farmers actually cherish their crops. So we go in there and we destroy their crops, and in that cases, those crops has to be quantified and compensations paid. So we decided to put in this very provision. Within 10 working days, the official surveyor or licensed surveyor shall inform the Director of Survey of any damages, and the damages can be farm or any other property that has been damaged to land during the survey for valuation to be carried out. This is very, very, very important because owners of the property will demand compensation, and therefore destruction of such properties will have to be the Director of Survey or the appropriate authority must be informed of such destructions. Then you look at section 26, 27, 28, erection and protection of boundary marks and survey beacons. I don't want to go into the act because I suppose you have it, you can read. But if you read section 27, 26, it talks about erection of boundary marks. And so we put in this provision: a surveyor may, where the boundaries of a land under survey have not already been correctly marked in the prescribed manner by the owner of the land, mark out the boundaries of the land according to the manner of marking prescribed in the Tenka instruction. So you see that reference is also again being made to the Tenka instruction. So the Tenka instruction is very, very important. And at this point in time, it's about time we go back to it again to review and revise it and make it operational in order for it to have effects in the references of it which are being made in this particular LI or proposals that we are making. Now, section 27 also talks about penalty for destroying boundary marks. And we are saying that a person requesting for authorization to destroy, move, or alter a boundary or survey mark shall state in writing, reasons for that intention, pillar identity, location. This is very important. We have situations where our marks, boundary marks, survey beacons can be destroyed at any time without any recourse to the appropriate authorities who are actually owners of such marks. So this particular provision is saying that authorization has to be granted before any survey or boundary mark is destroyed. And therefore, these reasons has to be given, the pillar identity has to be given, and then location of where this particular boundary or survey mark is located has to also be indicated. And then we also said that the director may surcharge applicant for the replacement of such beacons. And this also can be seen in Act 127, section 18. So yes, you destroy a boundary mark or a survey beacon, and it has to be surcharged for it. You have to pay for its replacement. So the survey mark, we are saying not just only pillars that has been erected, but pre-marked points for unmanned area vehicles, UAV, like drones, and then also our cores, because our cores are also stationed on areas and they can be destroyed. So if a core is stationed on a building and at a point in time it has been decided, or it is decided that that building should be demolished, then it means that that building is going with the core. And in that case, the appropriate authority with the survey mapping division has to be informed. And for the replacement of that core, the person who is actually undertaking the destruction of that core will have to be surcharged for its replacement. And then 28 also speaks about penalty for obstructing survey. So a surveyor who is willfully obstructed or resisted from carrying out his duty shall report to the nearest police station, police post, and to the office of the director of survey. Yes, so this is also very critical for surveyors. You visit a beacon, and the next time you go, it is no more there. And that beacon has been taken away or removed by a road construction. You understand? So in that case, if you find yourself in the situation where a boundary mark has been destroyed, you have to report to the nearest post of police, and then also to the director of survey. Then appropriate action will be taken. Of course, then that particular boundary post has to be, as I mentioned before, re-established maybe somewhere, and then the person who is responsible for its destruction will have to be surcharged. A person who uses or through another person obstructs or resists a surveyor from carrying out his or her lawful duties is liable under Section 28 of Act 1036. So this is explicitly stated in Act 1036, Section 28, that if somebody resists a surveyor from carrying out his or her lawful duty as a surveyor, that person must be surcharged. Now, so we went into land valuation provisions and we decided to look out for situations where our services will be important. And so we are saying that all forms of survey in relation to valuation shall be directed and supervised by the director of survey. And this also has been made, this provision has been made in the Act itself, which is in Section 23 of the Act, Power to Direct Survey. And then also we went into the registration of title, and we realized that we can also make an input there, especially for survey mapping, inputs of areas likely to be affected by declaration of land title registration. So areas that has been declared for title registration, the status quo which exists, looking at the mappings and sectional master has been mapped already. Those areas were given out as contract to especially licensed surveyors who actually do the mapping. And we are saying that the director of survey shall supervise those mapping or surveys and control the survey mapping of those areas as affected by the declaration. So Section 93, 1, maintenance of boundary features. Where a beacon or mark is damaged, removed, or obliterated, the director of SMD may recover the costs of replacing the beacons of mark from the proprietor. I've already mentioned this. If cost is recovered by suits, expenses incurred shall be borne by the proprietor. So where are we now with the draft bill? So inputs came from all the divisions and all stakeholders, and I'm sure I stand to be correct, is it LISAC or GHIS made inputs. All the divisions of Lands Commission also made inputs. Those inputs were consolidated and forwarded to the office of the AG. So the next is for AG to make his comments and forward it to us. Maybe Mr. Surveyor Bocho is here, you can take us through the processes. But I think quite recently, either yesterday or 3 days ago, the draft from AG came. LC committee is there to sit on it, to look at the comments that has been made. So this is where we are now. But at this stage also, when the drafts come to the Lands Commission for inputs, there's also an opportunity there for others to make inputs to the draft bill. So I thank you all.
Thank you so much. I believe that this one too has been well delivered. And I hope that by this time, all the questions and other contributions are ready to come in. So without wasting much time, I will ask for your comments and questions or whatever contribution you have. But the two resource persons are seated here and they will take your questions as they come. So if you have any question, you can lift up your hand, you identify you, and then you will mute and then you speak. You can also use the chat the chat box to send your question and read it for you. But I think that there is one question already in the chat box, and so I'll read it now so that Sylvia Boche will take it. Then we will continue. The question is from Charles Usu Achampo. He says, "Thank you, Council, for this wonderful presentation. And please, may I get this part about the award? Did you say that is the same as judgment? Thanks."
Okay, thank you very much for your question. Yes, like I rightly said, an award is what is a term which is used in ADR resolution mechanisms. And so it is the same as a judgment of the court. When you go to litigation, what comes out is a judgment. What comes out is a judgment. But when you go through ADR, what will come out is called an award. And it is executed in the same way as a judgment of the court will be executed. Thank you very much.
Okay. I hope that your question is well answered. May we have the next question? Or your contributions can come in now. Yes. So that question has already been answered, Mr. Champo. Yes, any question? Those of us here too, if you have any question, you can. Yes, there's another question in the chat box. Please, is the executing of the award the end, or it has to go to the court for stamping, or something else has to be done? Thank you.
Okay, so I said from the beginning that ADR is consensual, meaning that the parties themselves agree to go to ADR. So under normal circumstances, when an award is given, which is binding, the party who is in default will have to honor it. But there are instances where the party will avoid to honor his side of the bargain. And in that case, you can take it to court for the execution. Don't forget that even in litigation, when a judgment is given, the judgment does not end the resolution of the matter. It determines who is right and who is wrong, who is the winner and who is the loser. There is another process altogether, which is the execution process. You have to commence a new regime in order to get or reap the full rigors of your efforts. So in the same vein, where the loser in an ADR mechanism process fails to honor his side of the bargain, you have to go to court for the judgment to be executed. And let me stress here once again that it is executed in the same way as a judgment of the court.
Thank you. Do you have another question? Not yet. We are waiting for your questions and your comments. But before that, let me ask one question to Sylvia Boche. So if one wants to go into full-time ADR issues, I want to start myself as an ADR expert. How do I get to do that? What is the route or the available route to do that?
Okay, thank you very much for the question. ADR, you don't need to be a lawyer before you can practice as an ADR. we as land surveyors, we possess the technical expertise to become ADR practitioners. But like I said in the slides, in the presentation, what you have to do is that you have to become conversant with the ADR principles and practices. You already have the expertise, but become conversant that, oh, as for this particular case, what I need to do is to mediate. As for this particular case, what I need to do is to opt for arbitration. You see, and you can enhance yourself by getting attached to. There are several ADR institutions, so you can get yourself attached to some of them. We have the Ghana ADR Hub. We recently the Act mandates for the establishment of the ADR center. Last year, or no, this year, that center has been established with the inauguration of the board. So the duty of that center is to promote more ADR practitioners in the field of mediation and arbitration. So once you are interested, you can go through a practical training, and then you get attached to any of these institutions. You attend their meetings, their seminars, and things. And once you are accredited to them, when a land issue occurs, you will be seconded, and you go and act as an ADR practitioner.
Okay, thank you so much. There is a question here by the first question in the chat box was asked by Charles Owusu Achampong. Second one by Patrick Ama. We have answered them. The third one, the name is Pilot. So sorry, I cannot identify you, but I see your name is Pilot. Section 27(1) of the Lands Act 2020 is frequently flouted. Is there any evidence where violators have been held liable in the past?
I have not heard of any evidence of violators being maybe charged or some action being taken against them. And that is why we have, I think there's a penalty for destruction of boundary marks in the Act. And that is why it is very important for that particular provision to be made in the Act 27. There's penalty, Section 27, there's penalty for that. But personally, I have not heard of anyone being personally held liable for destruction of any pillar. And let me go to the provision that we have proposed. (27). Yes, so 27, the director may surcharge the applicant for the replacement of such beacons. So there's a provision of the culprit being surcharged, and it has to be reported to the director of survey, and it has to be reported to the police so that we can take action against the person who actually caused the destruction of those pillars. If reports are not being made, there's no way, we don't have any evidence to hold somebody accountable for destruction of any pillar. So it is important that if you realize that any pillar has been destroyed, if you witness any pillar being destroyed, you have the obligation to report it to the appropriate authority so that action should be taken.
To add to what Director just said, I think there has been instances in the past where people have been arrested for destruction of survey pillars. Those were the times when what we call beacon inspectors, and they go around and inspect beacons. And so when they find out that a beacon is destroyed, the first point of call is the owner of that land where the beacon has been sighted. And but I don't know what is happening now, since they don't operate anymore. And so it is high time we take it up and then go back to the issue of beacon inspectors, and then we act on that. Thank you.
Okay, thank you. Thank you so much. Sylvia Eriko Kante, there's another question here for you. It says, protection of survey beacons and penalty. Please, may I know which type of survey pillar should be protected under the law? Is this type A, B, or C pillars? Do pillars used to mark a client's boundary parcel corner marks come under this law?
Any survey beacon that has been erected by an officer of survey mapping division or a licensed surveyor, if such pillar, whether it's a boundary mark or a survey beacon, if such pillar gets destroyed, the act requires that that person should be held responsible. So any pillar, so long as those pillar has been erected by a person appointed by the director of survey to undertake that particular survey.
Okay, I hope you are answered. So any pillar that is, even boundary pillars will cause the most problems if you destroy them. Yes, there's another question here from James Ano. He says, my question has to do with section 23 of the Land Act 1036. Some planners are demarcating. The law also clearly states that drone surveys for the purpose of cadastre must be approved by the director of survey, yet they keep doing this at all levels of development. Because of this, their schemes look beautiful on paper and yet do not reflect the ground situation. So what is being done to have this law enforced at the ends of the special planning departments at all levels?
So that is why we made a provision in the airline that we are developing now. Demarcation and survey of draft planning schemes should be carried by the director of survey or a licensed surveyor. This is standard. This is the ideal case. But of course, what you just said is also right. Planners are developing their own plans based on whatever it is, maybe from Google Earth. You cannot actually validate the accuracy of such maps. So these are two bodies that need to collaborate, because we need them and they also need us. They prepare the plans, the schemes, and we implement the schemes on the ground. So we need that collaboration to be able to effect, the provision. They also have laws, but I don't think their law will also ask them to veer into our area in the preparation of maps for their schemes. So we need to collaborate. The key word is collaboration between the two agencies. So we all know our boundaries. They know their boundaries. They also know we also know the space within which we are working. So collaboration is key.
Yes, so it means that our work, if we all have to come together to make things work, otherwise things will continue to get out of our hands. I see Charles Owusu Achampo stand up. So kindly give him the floor to speak.
Good evening, sir. Good evening, sir.
Good evening.
And thanks for the opportunity, sir. Please, our deputy director, so your country made mention of demarcation. That maybe as we have been given opportunity by the director of survey, demarcating or alliance surveyor, and any confrontation or unauthorized person confront you, the person might be arrested or something. I didn't get that portion clear. Assuming that confrontation in a situation whereby you find yourself, these land guys have come to you because you have the power from the director of survey. Do you have to confront them or you have to leave the work because of the situation is not, good to you for that situation? what do you do? Do you have to confront them or do you have to come to office and report? If you can explain that portion well to us. Thank you, sir.
Okay.
Okay, so you have been appointed to conduct a survey by an appointing authority. Most probably director of survey. You are an official surveyor, you are a licensed surveyor. So you get to the site and you are confronted by somebody who is obstructing you from doing your work. Section 28 says that the person commits an offense, right? So a workman or a person who will fully obstruct or resist commit an offense and is liable on summary conviction. So you have to activate that, report to the appropriate authority, report to the police, report to the director of survey, and let action be taken against the person, because it is an authority which has sent you to the site to do a particular work. So, and of course, that if you are working on the premises of that particular person, the law requires that you notify him, give him adequate notice, for him to know that you are coming to work on his premises. But if in all of this, he obstructs you in doing your work, then you have to report to the appropriate authorities, report to the director of survey, report to the police, and let the law take its course.
Okay, I hope you are answered, but you mentioned about langas and stuff. Yes, the law, you are the rightful person. Yes, you are the rightful person. You have been given authority to work, but you must think of your safety. Maybe sometime you will not leave to come and report. So it is better you think of your safety. Yes, you get out of the place first, and then you report to the appropriate officers. Because we are educating ourselves. We wouldn't want anybody to confront langas. Right.
Thank you, sir.
Right. Do you have any more questions? Yes. There's a question here by Isaac Labi. I suppose that's our chairman. LSD chair. Thank you, Sovia Boche, for your presentation. In your view, what has been the effect of land surveyors in ADR, their do's and don'ts in the role we play? Maybe let me take it again. Thank you, Sovia Boche, for the presentation. In your view, what has been the effect of land surveyors in ADR, their do's and don'ts in the roles we play? I don't know that is the do's and don'ts in the roles we play. I think so.
Thank you very much, Mr. Chairman. I don't think we are practicing ADR officially yet. What I know we have been doing is to assist the courts in the adjudication of cases. This is a new area that we are trying to whip our members to go into, because, like I said, we have the expertise, we have the skills and knowledge to go into. And so we must, at this moment, make the conscious effort to whip up our members to go into that field. But as we speak now, I don't know of any surveyor who is practicing ADR. I stand to be corrected. I don't know of any of them. And once you are in the field of ADR, ethics plays a very important role, because you are acting between two parties, two feuding parties, and you are expected to be a neutral arbiter. So you must adhere to the ethics of the profession, which is land surveying ethics. You must also adhere to the ethics of ADR. They also have ethics that you have to adhere to. Some of such ethics are that you must be impartial. You must not be biased. And our work already puts us in that sphere. So I don't think we have anything wanting when we decide to go into that. That's why I'm saying that we should whip up our people to readily go into that field. Thank you very much.
We have two other questions here. Oh, okay. There's a hand up. Chairman Labi, please unmute and speak.
Thank you very much. Please, am I clear?
Yes, you are.
Yeah, thank you very much. And I thank Sylvia Butchie for his response. And this, my question goes to my Deputy Director, Sylvia Okante. In his submission under section 23, that is power to direct demarcation of survey. The second one talks of demarcations and survey of draft planning scheme. Why draft planning scheme? Because in fact, we've had a lot of challenges in the execution of these planning schemes. And you appreciate the fact that we have most of these planning schemes that have been implemented on the ground by these our planners. And here you are talking of draft planning scheme. Why the draft? Why not the final one? But it's rather the draft. Thank you very much.
My chairman. My chairman. Sylvia Labi.
Yeah, I'm here, sir.
If you read
Yes,
the
I'm
whole
here.
act, you realize that it has to be drafted, implemented before it is adopted. Right. So drafting, looking at the processes, it has to be drafted before it is adopted. Right. That's why we have the drafting and planning schemes over there, because the process will demand that you draft before the implementation is done.
Chairman Labi, I hope you answered.
Let's take it like that, because it is directly telling demarcations and survey of draft planning schemes. So
Yeah.
Here, my concern is, what is that draft planning scheme? Is it something that is not finalized, not approved, and we go to demarcate, or what? Talk of draft, what are you referring to? Because there are many times they do the planning schemes, initial demarcation is conducted, and then they go ahead to do some further rezonings without coming back to the director of service to see to that aspect of it. So talking of here, demarcations and survey of draft planning schemes, that's my concern here.
Mr. Labi.
Yes, sir.
When the scheme is drawn, right, there are situations where after implementation and as-built is done, there might be changes. There might be slight changes.
Yes.
I hope you are aware of that. And so the drafting is important before it can be adapted as, or correct or has been validated. It has to be drafted, implemented, as-built is done, and then it becomes the final scheme. You see, so the drafting is the initial stage, not validated yet, implemented, and then resolve it again. If there are corrections or shifts, you correct before it becomes the actual planning scheme.
Okay.
I hope I've answered you.
Yeah. Thank you very much.
Okay. All right. So the next question in the chat box is from Reverend Herbert Jabba. Please, what are the laws that regulate other surveys aside cadastral? Example, road and highway, mining, engineering surveys. Who regulate these?
Okay, thank you very much for your question. Like I said, any activity under this must have a law regulating it. We have the Mining and Minerals Act, which regulates the activities in the mining area. We have the Roads Act, which regulates anything concerning road. And so there are other laws which regulates every activity on our land. And as and when it is necessary, we have to do a recourse to the actual regulation, for you to apprise yourself with what the regulation says before you enter or venture into that area. So there are laws regulating every activity, but that I can assure you.
So I think that he's talking about directly survey aspect of those areas. So if it comes to mining, yes. If it comes to mining survey, what law regulates it? That's what I think is.
Okay, on that, we know that the generality of surveying is regulated by the director of service.
Yeah.
But when you go into the sub areas, for that, I think the specific entity, you see, like rules, we know it involves surveying. But once it is not cadastral, it doesn't come to the director of service. And so you may have to adapt to the road regulations to do that.
Anyway, but I think that the 767 Lands Commission Act, yes, it says that the director of survey is responsible, and one of his functions is to regulate these aspects of surveying as well.
Yes.
It says that, but I don't know how that one fits into. Maybe some regulations can make them functional. I don't know, some airlines or something.
Yeah, so that was exactly what I was going to say. Act 767 stipulates the functions of the director of survey, SM, survey and mapping division. And one of the function is to regulate survey and mapping activities in Ghana. It doesn't specify a particular aspect of survey.
Them.
Yes. Survey and mapping activities. So it includes cadastral, it includes engineering survey, all aspects of surveying has been listed. So maybe, as you said, we have to develop some regulations for 767, and that can capture into detail how those aspects of surveying can be regulated.
Because I think that the new technical instructions that a lot of these things were also considered. It's not only on cadastre. All right. So next question is coming from Surveyor Tina Wemega. Surveyor Dr. Tina Wemega, sorry. What is the way forward for land surveyors to be officially ADR experts?
I think this question was answered some few minutes ago. Maybe doctor was in there, but I have said that you don't need to be a lawyer to practice ADR. We already have the expertise and then the skills to do ADR. What we need now is to just apprise ourselves with the do's and don'ts of ADR. And the act, the ADR Act, specifies that the Lands Act also adds its voice to it. And I continue to say that to become an expert, a top ADR practitioner with a surveying background, you have to attach yourself. There are several ADR institutions. You have to attach yourself to any of them. You attend their courses, you attend their conferences, and then you must make yourself known. You see, you must make yourself known, write papers, deliver papers at such forums, and then once you are known, whenever there is an issue concerning land, you will rightly be contacted, and you will make your money. It is a very fertile ground for we as land surveyors. So I encourage us to venture into it. Thank you.
Thank you. I think my understanding the last time too is that GHIS is an ADR center.
Yes.
So yes. You are already at home. So maybe you contact the right authorities for them to adapt you. I am taking the lead. I am going right from here. I'm going into ADR. So you can join me. The next question is from Nathaniel Mensah Dawusu. So at what point do we have an approved local plan?
When it has been validated by Survey and Mapping Division. So the plan has been drawn. It has to come to us for validation, just to make sure that what has been drawn on paper conforms to the ground. So when that is done, then it can be approved as properly. It can be approved as a validated plan, for use. So the local plan necessarily has to be validated by Survey and Mapping Division. That's why I spoke about the collaboration between Lands Commission and LUSPA. That collaboration is very, very important.
Thank you. Alaji, I think I saw your hand up. Okay, please.
Thank you, Chair. I wanted to respond, add an answer to my chairman, Rabi's this in connection with the what you were saying, the draft. Yes, I had that experience that after the base map, we took this thing to the planners. We didn't know that there was a slope somewhere. So when you were demarcating, you saw that you can't get that plot or the plot along that valley. So what we did was to maybe inform them. Then we zoned the area again. There are some places maybe we didn't take the topography into consideration due to other unforeseen circumstances. So that is what we took as a draft. So you have to rezone it again. So that is what Deputy was saying. We have to resurvey and then redesign it again.
Thank you. I think this brings clarity to the draft issue. Right. Do we have any more questions? I think that, yes. Mr. Dawusu, would you like to talk or you write? I see follow up. Is that the practice now? I don't get which one you are asking, please. We don't know which one you are referring to as a practice now. So if you can come clear. So we have just 2 minutes to leave. So if there are no more questions, we would like to take the last words from the panel.
I would like to ask, during my presentation, I wanted a clarification on the stages through which a LI draft goes through to the final stage. And so I'm not a lawyer. We have a lawyer here who can probably take us through. Are we at the last stage or are we at the initial stages? As I mentioned before, now the draft bill has gone to AG. It has come back to LC for, further clarification on some issues or points that they raised. So at this point, where are we? Are we far away from getting to the end of it, or are we just in the initial stages?
To answer your question, you are very far away from the end, because once it has gone to the AG and it has come back, it comes back with their comments. They will be requiring of you to answer the comments. Once you answer those comments, it goes back to them, and they will still go through, and they will still find some faults. It will be just on and off and on and off and off. It is when the AG, they are okay with everything, every drafting, that it will even go to Parliament. And so you are nowhere let's take a look at the Surveying Council bill. I'm a member of that committee, and it's about 20 years now. It has been going back and fro, back and fro, back and fro, and the last time it went to the AG, they looked at it, they brought it back, we looked at it, we answered their queries, it went back, and it's still hanging in the air. So you are very far away from the actual end.
Okay. But anyway, because this one is an LI, I hope that it will come faster than the normal act.
Let's hope so. Let's hope so.
Okay.
Yeah.
Right. So can we have your last word, Sylvia Butchie?
Okay, so let me take this opportunity once again to thank the organizers for this opportunity. I think it's a very good opportunity, a nice one as such. And like I said, I will encourage each and every one of us to try our hands in the ADR field. Maybe we've been doing it, but unconsciously. This is a time for us to make a living in that field. And I can assure you, once you equip yourself with all the necessary skills, the do's and don'ts, the sky will be the limit. So once again, thank you all for this opportunity, and I hope we will reconvene again to tackle some other areas of ADR so that we'll be in the right stead as we venture into that field. Thank you very much.
Thank you.
Yeah, I think we are all aware at the stage in which we are now in the development of our LI. I think it's still at this stage open for more comments, more inputs from stakeholders. So we are still at a long way to go, but we also have the opportunity again to put in more inputs. What I just presented are just inputs from SMD Lands Commission, but of course inputs can come from anywhere again within the survey and mapping community. So inputs are welcome. So let me again also take the opportunity to thank the organizers of this particular CPD, and I think it is worth it. We have been updated as far as the LI for 1036 is concerned, and I think that the survey and mapping community must get involved and push this thing to the end, because at the end of it all, it is to our benefit. Thank you, Chair.
Okay, thank you so much. On behalf of the chairman of the LS division and the surveying fraternity, I would like to say a very big thank you to our resource persons for their insights. We are so grateful. At this point, I will take this opportunity to extend the ESCO led by Surveyor Labi. The ESCO's thanks to all members of the division for their support during the burial of Hackman's son. And then also at the 1 week of Surveyor Beams, Mr. Joseph Ochre, the 1 week ceremony at Kumasi. And one last announcement, the CPD secretary is also bereaved. His dad is down. So come weekend or next week, we will be heading to Takrady to also give him the support that you gave the others. So thank you so much. So at this point, shall we rise for the anthem, and then after that we take a prayer, and then we call it a day.
I beg, go to WhatsApp. Yeah, WhatsApp, in fact. instant message. Yeah, WhatsApp. Yeah, announcement.
Okay. Before we pray, one last announcement. The chairman wants me to inform you that on Sunday at 7:30, there's going to be ESCO and the subcommittee chairs meeting via Zoom. So watch out for the link. And then after that Sunday, the Tuesday that follows at 7 p.m., there's going to be LSD general meeting. And among the things that will be discussed will be FIG preparations for Australia 2025, and then preparation towards EGM in December. You know, in December, we have to attempt to elect or submit the names of our nominees to council for next year's GC. So these are the announcements. Shall we take the closing prayer? If we can have a Muslim prayer, fine, but if not, let's pray. Father in heaven, we thank you for taking us through this event. We are so grateful and we want to give you the glory that your name deserves. As we live here, we are not leaving your presence. We pray that you guide us, take us and provide the safety and the traveling message to wherever we are going. We ask that you be the one that will take us to everywhere that we go from now onwards. We want to commit everybody into your hands, that everything that we are doing and everything that we'll be doing will become a successful one. So we have the cause to give your name the glory that it name deserves. We ask you this and we are grateful for everything in Jesus' name. Amen.